Legal status of currency, negotiable instruments, and common misconceptions. 1. Legal tender in the United States. You must recognize that U.S. coins and currency, including Federal Reserve notes, constitute legal tender for all debts, public charges, taxes, and dues under federal law. You cannot refuse legal tender and demand gold or silver in ordinary private debt contexts. Private parties may contract for particular payment media, but absent a valid and enforceable agreement to the contrary, lawful money satisfies monetary obligations. Footnote. This section establishes that Federal Reserve notes and coin are legal tender that discharge debts unless a valid contract requires another medium. 2. Scope of UCC Article 3. You should distinguish money from negotiable instruments. Article 3 governs negotiable instruments only and expressly does not apply to money. A negotiable instrument must be a written, signed, unconditional promise or order to pay a fixed amount of money, typically payable to bearer or to order, and it must not be subject to additional undertakings beyond limited allowances. Footnote. This section defines what Article 3 covers and lists core elements required for negotiability. 3. Invoices and utility bills are not automatically negotiable instruments. You should not treat routine invoices, statements, or utility bills as bills of exchange. Most such documents are requests for payment that fail negotiability requirements because they are not unconditional orders payable to bearer or to order, and they commonly include additional undertakings or contingencies that defeat Article 3 status. Footnote. This section explains why ordinary billing statements typically fail the test for negotiable instruments. 4. Endorsements and the phrase without recourse. You must understand that writing without recourse limits endorser liability on a negotiable instrument but does not extinguish the maker or borrower obligation on a loan. You cannot unilaterally alter a credit contract or erase a debt by adding endorsement language to consumer loan paperwork or payment devices. Footnote. This section clarifies that endorsement disclaimers affect endorser liability only and do not cancel borrower duties. 5. Federal Reserve discount window and account access. You should know that access to the discount window and master accounts is limited to eligible depository institutions that meet regulatory and supervisory standards. Individuals and ordinary businesses cannot obtain window credit by filing forms or attempting to pledge retail credit instruments as collateral under Operating Circular 10. Footnote. This section states that only regulated institutions, not private individuals, may access Federal Reserve credit facilities. 6. IRS Form 1099-A is not a payment instrument. You must treat the 1099-A as an informational form used by lenders to report acquisition or abandonment of secured property. You cannot tender a 1099-A to satisfy a private debt or to compel a creditor or the Treasury to pay an account balance. Footnote. This section emphasizes that 1099-A reports events and cannot function as money or settlement. 7. Nationality, passports, and self-naturalization claims. You should follow statutory procedures for naturalization and nationality. You cannot obtain U.S. nationality or a passport by self-issued certificates or unilateral declarations. The narrow category of nationals who are not citizens arises by specific law and does not result from private paperwork. Footnote. This section confirms that nationality and passports arise through statute and agency adjudication, not self-declaration. 8. Litigation, arbitration, and sanction risks. You must expect courts to reject theories that invoices are bills of exchange, that endorsements void loans, or that retail debts are payable by government fiat. Filing altered instruments or refusing payment based on these claims risk default judgments, fee shifting, contempt, and sanctions. Arbitration may limit discovery, but it does not validate unfounded legal positions. Footnote. This section warns that pseudo-legal debt elimination tactics fail in court and can produce penalties. 9. Lawful strategies for debt relief and credit improvement. You should pursue established remedies such as hardship programs, nonprofit credit counseling, negotiated settlements, or bankruptcy when appropriate. You should also rely on relevant FICO models for underwriting contexts such as bank card, auto, and mortgage, obtained from reputable providers rather than informal estimates. Footnote. This section directs you to compliant, effective avenues for resolving debt and managing credit.